You need to do findings of fact and conclusions of law so that I have an appealable or reviewable order.
I'm ready. I'm ready to do that. So,
Well,
do you have anything else you want to say? Okay, State of Nevada versus Blandino, case C 341767. Will the state make their appearance?
Mike Dickerson, another Marlin, on behalf of the state, Your Honor.
Okay, and it appears as though Mr. Blandino is appearing via blue jeans. Mr. Bateman, do you want to make your appearance?
There we go. Yes. Ben Bateman, 10933 by counsel.
Kim Blandino, State for Kim Blandino, again entering a continuing objection to this blue jeans. I can't see people, can't hear people. I'm going to be interrupting because I can't see faces and tell body language. It's ridiculous. I need the court to know immediately, though, that I filed another motion to disqualify Leavitt and Jones, filed 1239.
Okay,
So, yep.
I got it. Okay.
Yep.
All right. So the first thing up.
So you can't do anything going forward.
Okay. And it appears as though he filed it right after the other one was denied.
Right, and it's
So,
similar.
kind of making my point for me.
Yeah,
So,
and it's similarly deficient, Your Honor.
okay. And so the first thing we're going to deal with is the state's motion requesting that the court revoke Mr. Blandino's pro per status.
I didn't understand. What happened with this motion to disqualify? Are you denying your own qualify
No.
you?
No, I'm not.
Well,
I'm
you can't
not. I'll get to it. I
You
think
cannot-
it's been filed in bad faith. It's filed in violation of the rules.
It's not your call.
Here's the thing, you can't just wait for the court to issue an order and then file a new motion. The last 48 hours, I think he's filed 3.
Yeah, and this one, like the others, is untimely. It falls outside the rules untimeliness, as well as it's not supported by an affidavit which indicates the specific reasons for disqualification.
And it's
So,
probably about the 18th one.
and it's the same reiteration of everything that he's been finding. I think this may actually be, it's the 18th or 19th, Your Honor, or somewhere around there, and he keeps making the point for himself, right? We've brought this motion over and over. We've supplemented our prior motion. Your Honor has put the defendant on notice of his obstructionist behavior. Your Honor found 2 days ago that he was continuing to obstruct. His failure to appear in court was obstructing. Everything that Mr. Blandino has done in this case has been antithetical to the right of self-representation as contained within the United Supreme Court case, Beretta. He is absolutely using his self-representation as what he believes he has a license to obstruct these proceedings and to commit egregious misconduct. He's doing it over and over and over again, and I think that you take a look at the case law on self-representation, and you can go right to one of the Nevada Supreme Court cases, Tanksley. In Tanksley, Tanksley was denied the right to self-representation based upon the trial court judge having seen Tanksley's performance previously representing himself and finding that it was undoubtedly obstructionist. Here, Your Honor has the benefit of also seeing Mr. Blandino's self-representation, his conduct before this court in this case. Mr. Blandino has been given chance after chance to conform his behavior to the rules, to stop obstructing these proceedings, and to quit with this misconduct that he continues. I think that it's been made clear through my moving papers that based upon the mental health diagnoses that we have seen Mr. Blandino diagnosed with by Dr. Hansen in this case, the personality disorder with narcissistic, schizotypal, and obsessive traits, and seeing what that means, it becomes clear that Mr. Blandino is never going to get off this path. And it's become even more clear because he's been given that opportunity. At this point in time, Mr. Blandino has left this court with no other option. He is essentially asking this court, every time he responds to a motion that has merit by the state that says, hey, Your Honor, you need to take a look at his self-representation, and he does it by responding with yet another meritless motion to disqualify, it's Mr. Blandino essentially telling this court, yes, Your Honor, There's no other option. You have to take away self-representation.
Blandino, do you want to be heard?
I absolutely want to be heard. Only what he said is nonsense. I got to reiterate, under the statute, a motion to disqualify is filed. You cannot rule. It's black letter law. You cannot
Okay.
rule.
All right,
Pause.
you can move on. You can move on because I'm not going to go through it. So move
That's fine.
on. You've made
Okay,
your
here-
record.
Go. It's irrelevant whether it's the 18th or 19th. Thomas Edison was asked when he had 5,000 failures to do the light bulb. He said, "Well, what did you? I mean, it looks like you failed." He says, "No, I just know 5,000 ways that don't work." But the point is here is that it took me multiple applications till I finally got Judge Wilson, which is a judge outside the district, which I was asking for in part. So you cannot even include those up until that, because I achieved success in part because I got a judge to finally rule on it from outside this district. Now, what makes it different between then and now? And here, this is ridiculous. It says 3 a.m. on this minute order where you denied the motion to disqualify yourself at 11:20 today. I didn't get it because I didn't check my email until later. But you filed this at 11:20 today, and the very same motion is 11:42 denied by Tierra Jones. What are you playing, tag team, or are you some kind of appellate district court? I mean, this is bizarre. And moreover, these are minute orders. You have been told over and over and over again by the Nevada Supreme Court, a minute order is ineffective for any purpose. It's black letter law, Russ versus Clark County School District, because you could change your mind. And as to minute orders and transcripts and doing filed orders, 3 months ago, you directed the district attorney to file a written order, prepare the order, keeping me away from Nordstrom and Federico. That hasn't been done, but your job is to supervise what they do. So the wrongfulness for that lies at your doorstep. What you have is with yourself is incompetence, corruption, and I think there is some mental illness or something going on in your head. My wife, who's the same age as you, had a tumor was removed. It was growing there for 20 or 30 years. It wasn't until she lost her little ability to speak that they found it, and it was about the size of a baseball. She hadn't sent me the pictures yet. But she's exactly the same age as you, depending on the month you were born. 1965 was the birth year. So, you know, with this thing to actually run over there and say that these motions are meritless, no. Ripro, Echeverria, and those two cases that came out of here where Judge Lehman and Judge Bongiovanni knew they should have disqualified themselves, and they didn't. These men, now, by all accounts, they're not good men, but bad men can make good law. Look at Miranda v. Arizona. The thing is that they waited 30 years, and there's a co-defendant in there, Carlos Gurry. So really, Lehman and Bongiovanni should have been charged, investigated, charged, and prosecuted for the same thing I'm going after you and Tierra Jones for. That's oppression under color of office, which is NRS 197.200. You keep running over my rights, and I'm supposed to just say, "Thank you, ma'am, can I have another?" It doesn't work that way. The fact is that I have to resist this violence upon my rights with every fiber of my being and every lawful tool. And this motion to disqualify is it. You won't even follow that. When it says the thing is filed, it has to be heard by a judge agreed upon by the parties, and if they're unable to agree, by a judge appointed. That did happen in part when Judge Wilson was appointed. But then what happens when he shows a few flaws, which I filed and amended, then Tierra Jones jumps back in. Now, neither one of you have been filing even any affidavits in response. Your duty is when you get the motion to disqualify, either transfer it immediately or file a challenge within 5 judicial days. And it used to be 2 before then Chief Judge Gonzalez.
Respond to the state's motion to have your self-representation revoked.
Well,
I understand your position completely on the motion to disqualify. I'd like to hear your position on the state's motion to revoke your pro per status and appoint an attorney to represent you.
Pro se, not pro. I absolutely reject that. I can walk, talk, and chew bubble gum as long as I'm given permission to chew bubble gum in a courtroom at one time. And there's no attorney there as capable as I am, and they can marshal the facts, the knowledge, and everything I need to defend against his charges. These charges are all going to depend on was my specific intent to extort or to impersonate. The witnesses that I have, even my own testimony will show. And in that regard, the DA is withholding exculpatory evidence under Brady v. Maryland. And so I know the case law, I know the procedures, I know how it's supposed to do. If you take away my self-representation, it will just be the most another egregious miscarriage of justice that there is. I mean, they don't have the basis for it. I mean, I know the rules. I know how to follow the rules. You're the ones that don't know how to follow the rules. You don't know how to follow the statutes. You want to do just whatever the heck you want. You want to be the legislature. You want to tell the legislature what the law is. Well, we'll obey this one, like cafeteria Christianity. I'll take this one and that one and that one, but I'm not going to do that one because that's too tough for me. So the whole thing is about motion to revoke. The standard is, do I understand the nature of the charges? Do I understand the process or the procedure, the judicial procedure? And can I assist my counsel, which is me, in the defense? And it's yes to all three questions. Now, I've leveled my objections here against you. Disqualify. You said to move on. Okay, I'm moving on. I still maintain that objection. I intend to go to the Nevada Supreme Court one more time because I'm entitled to due process here and an impartial judge even in pretrial. I have not filed even to get a motion to see my son Andrew. He's going to be a PhD. Commencement starts on December 9th because that would waive my objection to you because you're not impartial. So the discovery issues, the impartiality, I have all these things, in hand. But, I've just been hoping that you, Judge Jones, and the other Judicial District Court judges would come to your senses, seen my resolve, and do the right thing here. And I don't think that's wrong because you're not God and you're not the Nevada or U.S. Supreme Court. You're not the federal court. Because I've read enough cases. The federal court will say, what the heck were you doing down there? Why didn't you just err on the side of caution and let Blandino have a judge from another district? This just makes absolutely no sense. But if I go to the feds, exhausting all my remedies, take me 20 or 30 years, you'll be on the bench, you'll be in the Bahamas sucking down Mai Tais or whatever on the beach, Judge. Hopefully that you live that long. And the thing is that you know that I can argue the case. You know that I know the facts. And the thing, if you revoke my self-representation, I have to take that one immediately to the Nevada Supreme Court on extraordinary writ. Now, I don't know what they're going to do, but I'll do a simultaneous petition to the federal district court on a habeas pending the exhaustion with the Nevada Supreme Court because and that's why you haven't done it so far. All the people on the web said, why doesn't you just revoke it a year ago? Because you know what a severe sanction that is to take away my self-representation, especially when, and I'm not bragging here, God has given me certain abilities that I haven't seen in very many pro se litigants. I just have those. He's given me this. And so to give me substandard counsel, and I don't care how many bar degrees he might have he could have them from all 50 states. He couldn't do anywhere near the job in defense that I could do with one arm tied behind my back. As Rush Limbaugh said, with half my brain tied behind my back. They couldn't, God rest his soul, actually. He's passed away now. But the whole thing is that they don't have the basis for revoking counsel. And they want to talk out of both sides of their mouth. Well, she's incompetent, but then we want to revoke counsel. And that was another mistake there. You took away my competency, and then you didn't revoke my counsel then. Because if I was incompetent to proceed forward, there's a lot of case law that says, Well, then you got to appoint counsel, because how can he represent himself? If he said he's incompetent or his competency's in doubt, then you got to appoint counsel for him. But you didn't do that. So the DA actually had a point when they raised that early on in this case. But, I've never waived my rights, my speedy trial rights. You struck an amended indictment while a motion to disqualify was pending. Do you know how egregious that is? And this was an amended indictment that I entered a plea to. And so there's some heck of constitutional issues there. How many?
Indictment the state filed in preparation for him to enter his guilty
plea
Yeah,
that he never entered.
right. That he indicated in a letter to me that he had the intent to enter, and he never entered any plea on that amended indictment.
Well, then the DA should have waited until open court and filed it in open court after I had said, yeah, I'm willing to enter a plea. He's done stuff in open court. That's no excuse. He knows in his heart, the DA knows in the heart that they're overcharging with extortion and gross misdemeanor. Not that they're not overcharging with gross misdemeanor, both, but they're way overcharging. He knows. He knows me for 2.5 years, just about. And he knows that he's not going to be able to bridge that gap of specific intent. There's no way they can prove I intended to extort. There's no way they can prove I intended to impersonate an officer. I said I was a volunteer, unpaid investigator working with the Commission on Judicial Discipline. And no one that I represented that to, Linda Bell, all the other judges said exactly the same thing, said, oh, wait a minute, we need to refer for charges. They didn't do it. This is because Federico, the complaining witness and alleged victim in this case, has some juice. And so he's trying to protect his career. He's a temporary judge, and he knows that I can go to the county commission in the city of Las Vegas and have his ticket pulled to be a temporary judge based on what he's done. He lied with a temporary protective order, and he was denied that application before Judge Jansen. So, there's somebody that has some juice, and so if you keep Blandino busy, it'll protect his career. So this is just a bad faith prosecution. It's vindictive prosecution. And if you're going to go ahead as judge in this case, maintain my right to self-representation, then I demand immediately to have evidentiary hearings on the vindictiveness of the prosecution and to show that I have already been punished for this, double jeopardy, both in the competency proceedings and the ankle bracelet when I was on a high level. That statute's not going to pass constitutional muster, where it says that a judge, with the approval of a judge, a person can be put on GPS as though he were a convicted person. And that's what my house arrest officer told me. I'm being punished in the same way that a convicted person would be punished. And therefore, under Desimone v. State, you can't punish me again. So these issues are just dynamic, and they're not anything. Desimone v. State, 116 Nevada 195. That's the 2000. So it's technically Desimone 2. And that was a civil. He was a drug dealer. In the civil case, they executed an amount greater than what he should have paid in taxes on the drugs. He was convicted, and they reversed the conviction after going to the U.S. Supreme Court and said, wait a minute, you punished him with that taking more than the taxes were, so therefore the conviction had to be reversed. Now, when I was at Lake's trial.
Anything else regarding the self-representation?
Well, Judge,
I understand you object.
But okay, I demand as a matter of law that if you do revoke, you need to do findings of fact and conclusions of law so that I have an appealable or reviewable order.
I'm ready. I'm ready to do that. So,
Well,
do you have anything else you want to say?
Well, I just say I object to the fact that these minute orders, again, they weren't findings of fact and conclusions of law. So, are you, Judge? Are you going to issue that order? Because I got a civil suit against Federico, and I can't contact him to serve process. I had to put an extension of time in my federal case. So until I get a written order, I can't ask for an exception so I can do civil process in that federal case. So you've been negligent in your duty. If you can't do the job, Judge, resign from the bench, please.
Okay, I appreciate that. Okay, so at this time, have you said everything you wanted to say?
Me?
Yes.
No, I could go on for another couple hours.
All right.
Okay. So the right to self-representation is not an absolute right. The problem in this case is that the defendant refuses to accept the jurisdiction of the court, which is basic to the rule of law. He's filed multiple, please do not interrupt. You can wait till the end and then you can make your objection. He has filed numerous 15 plus motions to disqualify. Every time one gets denied, he simply files another one. In the last 48 hours, he has filed at least 3. In fact, today, after a minute order was issued denying one of his motions to disqualify, within minutes, he filed another motion to disqualify. The motions to disqualify are all meant to obstruct, impede, and manipulate the court procedures and prevent the court from proceeding forward against the defendant and setting the matter for trial. The matter was actually heard by Judge Wilson. That I don't even know how many motions to disqualify in, because every time it got transferred to a different judge, in the 8th to rule on the motion, he would file a motion to disqualify that judge. There's no other explanation than he meant to obstruct, impede, and manipulate the legal proceedings. Judge Wilson, who was appointed by the Nevada Supreme Court, who is from another jurisdiction, said the case was delayed more than a year based on these motions, that he failed to allege legally cognizable grounds supporting a reasonable inference of bias or prejudice, and that summary dismissal was appropriate. He recognized that the facts raised concern defendant has sought delay to manipulate his court proceedings. Judge Wilson found that the allegations were baseless attacks on the court. He provided no facts to support his opinion that all the judges in the 8th were guilty of misconduct and corruption. Again, called them baseless attacks, and he called most of the allegations pure speculation and innuendo. The allegations are not legally cognizable grounds supporting a reasonable inference of bias. His claims are not legitimate. They are not made in good faith. They're made to gain a tactical advantage in his criminal case. He has not only filed these types of motions in Department 12. He tried to do, when Judge Jones tried to do an order to show cause, deeming him a vexatious litigant, what did he do? He filed a motion to disqualify Judge Jones. Even though a recent motion to disqualify Judge Jones had just been denied, he ignores the orders, he ignores the rulings, and just continues on with the motions to disqualify. They're made in bad faith, they have no legally cognizable grounds in them, and they're not appropriate. He's doing it for purposes of tactical gain. Based on the record, there is absolutely no question in my mind. He's using this to manipulate the court proceedings and prevent the state from proceeding against him. He refused to follow the rules. He refused to follow the mask mandate that were put in place as public help. He stands at the courthouse and demands to be let in the courthouse without a mask. When he's given an opportunity to appear via blue jeans, I'm grateful he appeared today, but on Tuesday, he refused to appear via blue jeans, and he refused to put on a mask and comply with all the rules that every person that comes into the RJC is required to follow based on public health policy. Okay, but now that the court is proceeding against him and indicated a bench warrant would be issued for his arrest, now he appears via blue jeans. Also, in his attempt to prevent the court from proceeding, came to my attention, he filed an application for a TPO in Justice Court against this court, contending I had committed aggravated stalking against him. Again, it is not in good faith. It's bad faith on its face. And again, it's a desperate attempt to obstruct, impede, and manipulate. And he only filed that after it appeared that he was not going to be able to continue to file these motions to disqualify. Again, the right to self-representation is not absolute. The court may revoke a defendant's right to self-representation. A defendant can be competent to stand trial and still not competent to represent himself based on being completely disruptive, an obstructionist, and manipulating the court proceedings. He has abused his right of self-representation by being disruptive, refusing to comply with the rules, refusing to accept the orders of the court, refusing to accept that the court does have jurisdiction, and ignoring the rule of law. His conduct has become so disruptive, manipulative, that I have no confidence that we would be able to proceed in a manner if he was permitted to continue to represent himself. He's abused his right by disrupting the judicial process. He is entitled to a fair trial. He's not entitled to abuse the system and make a mockery of the criminal justice system along the way. He's unwilling to abide by the rules, and so therefore, the court is going to revoke his self-representation based on all the conduct up to this date. I was hoping that Mr. Blandino would at some point come around, especially after I warned him that I would do this and that he would start to comply, but I have absolutely no faith whatsoever that he would comply. There's a strong indication that if he was permitted to continue, he will continue to be disruptive and continue with his obstructionist behavior. And therefore, I'm not going to allow him to represent himself. His conduct is deliberate and it's meant to obstruct the proceedings. So at this time,
I am gonna order that Mr. Bateman be appointed to represent Mr. Blandino.
You said I could enter my objections after you got done speaking, though, first?
Go ahead.
Before, so the revocation is pending. Objections then, correct?
I'm sorry. I didn't hear that. Say that again.
I'm saying that you're pending my objections, which you're allowing me to do, then you'll revoke after my objections, right? Because otherwise I don't speak.
Go
Huh?
ahead.
Okay.
Go ahead.
I didn't want to be cited with contempt. Okay, you mentioned the rules probably about 20 times in that dialogue, that you won't point exactly to what rules I violated. You know, the obstructionist and the person's violated the statutes, and I pointed exactly to those statutes that
Okay,
you...
all right. Your objection is noted. It appears, again, he doesn't want to address the issue. Based on your
you have repeatedly used your right to self-representation to abuse the dignity of these court proceedings. Therefore, the court is going to revoke your ability to represent yourself. You're going to be appointed counsel. Mr. Bateman will be appointed counsel to represent you in this matter. Since you are represented by counsel, you are not permitted to file any pleadings. They will not be accepted by the clerk. Okay, so Mr. Bateman, I know.
I'm willing to change, tell her I'm willing.
Yes. So what, obviously, going to be sworn in, is the trial date, the December 6th trial date still?
Okay, well, that's what I was going to ask you. Can you be
Okay.
prepared to go forward on December 6th?
No, Judge, I would need, do I need to do a motion to continue or need to be sworn in? Away. But there haven't been any subpoenas issued or anything like that.
How much time do you think you'd need to get ready?
What is the ordinary course for your department?
Well, I'd like to do it within the next 30 days, if you can be ready.
I mean, look, I've been on this case, and Your Honor did tell me to expect this, so, forewarned is forearmed. 30 days. I would say 60 days would be more realistic given my caseload currently. 90 days would be better, but 30 days, I just with the holidays and my own court calendar, 30 days I don't think is realistic.
And Your Honor, we have pretty significant trial schedules on our ends as well. I don't know if Your Honor would entertain possibly setting a short status check so Mr. Bateman and I can get together and take a look at our calendars with the court.
I would have, that probably be a good idea. So I want to give Mr. Bateman an opportunity to review the motions that have been filed by the state as well. So, Mr. Bateman, why don't I put it on in 1 week for a status check? And then the parties can represent when you want me to set it for trial.
That's fine. Let's see. That'll be the night. And what exactly is Mr. Blandino custody status? Is he on electronic monitoring? Is it high level?
Electronic monitoring. Oh, and I was gonna say, if Mr. Blandino wants to be released to go see his son, I have said several times that I would be inclined to do that. So if the defense wants to present an order,
Yes. I think he indicated, what is it, next week on the 9th?
Well, his PhD thing is on the 9th, his commencement for PhD.
Okay. That would be, okay. I'll submit an order, Your Honor. If Your Honor.
we're just gonna need to indicate the days he would be gone, because he's gonna have to go to house arrest, have the bracelet taken off, and then come back and have it put back on.
Understood.
So that's next week. Do you want me to set this here?
No, set it 1 week. What is,
He just said he's gonna, that thing is on the 9th
I
in
know,
1 week.
what's Tuesday?
That's going to be December 7th
Perfect.
at 12 p.m. for status check.
on trial setting and the motion, state's motion.
Okay, and the state can prepare the order revoking, granting your motion and revoking his self-representation.
Okay, Your Honor.
Okay, thank you very much.
Can we have a transcript of this hearing, Your Honor?
Sure.
Thank you.
Absolutely.
Thank you, everyone.